Hi everyone, I am with Ms. Shivani Sanghi, who's a partner in the Litigation and Arbitration practice with Bryan Cave Leighton Paisner. You are in the London office.
Yes. I am fronting the India practice.
Yes. Okay. We've had so many conversations in and through the last 2 days on various aspects of arbitration. One of the things, though, I think which we all know is that the process involves costs, it involves fees, and it can be expensive. It's difficult for us to really understand going into an arbitration or into a dispute resolution process, how much fees we're going to incur. I know that we were speaking before we started recording on various ways that we can manage fees. This may be particular to an international context and may not be strictly relevant in an Indian context, so we have to maybe clarify that. But with that disclaimer, Shivani, what are some of the ways that we can manage costs?
We were talking about alternative fee arrangements, and this is something UK law firms, US firms, UK and US lawyers can do. Of course, with Indian lawyers, they can't take part in any contingency fees because that's seen as champati and it's not allowed.
Yes.
But as a UK lawyer, in terms of alternative fee arrangements that we can offer some of my clients, one is CFAs, which is essentially the client pays say 70% of the rate going while the arbitration or the litigation is on foot, and once you have success, whether that may be because of settlement or enforcement or an award or a judgment, depending on how it's defined, the remainder 30% will be paid on a successful outcome. Plus, there's a slight uplift. But in case you don't get a successful outcome, you only pay the 70%, and the law firm will never get the additional 30% or any uplift on it. So I think that's something that clients find quite attractive because it kind of makes the law firm have skin in the game along with their client. And of course, we're all trying to do the best for our clients, but I think that kind of arrangement is gaining more popularity with clients. So that's one. Then the other one is damages-based agreements, which is DBAs. And that's, in a very simple layman term, that is a no-win, no-fee solution. So the law firm, lawyers would take a percentage of the award or the settlement or the judgment once there's a successful outcome. But while the process is ongoing, the law firm is essentially getting nothing. Right. Yeah. So that's a huge risk the law firm is taking. But then you invest in a case because you say this claim is good, I believe in the merits of this case, so I'm going to back it up. And a lot of times with DBAs, you also have third-party funders come in.
Yeah.
So with DBAs, for example, let's say there's an arbitration, and so the lawyer would go on a DBA, so that's the law firm's costs. But what about your expert's costs, your tribunal's costs, any other disbursements that come on top? Those are hard costs, and a law firm can't really bear that. If the client doesn't want to bear it because they want a pure no-win, no-fee solution, then you can have third-party funders who will fund the other aspects of the case. So your tribunal fees, your institution fees, your expert fees, lawyers as well, if they want to do so. And so the client doesn't pay anything until they get an award. And then the third-party funder would either take a multiple or a percentage. I mean, with the PACCAR judgment in the UK, that needs to be very carefully worked out.
Okay, so I think you need to give context on this judgment because it's entirely likely that we all don't know about it.
Yeah, so it's just what the courts in the UK have said is that for a litigation funding agreement is now to be governed under the DBA regulations, which is the damages-based agreement regulations.
So there is a regulation for that?
Yes, in the UK that regulates me as a solicitor when I enter into DBA with a client. So and there's a lot of controversy about that. So there's lots to speak about it. I won't go into detail. And there is a bill which may overturn the effect of that judgment, but it's not been passed yet.
What does the judgment say? What's the bottom line at the moment?
So I think the bottom line is that the validity of litigation funding agreements, which charge a multiple of the money invested and a percentage of the award or judgment, it's not free of doubt, the validity of these agreements. And of course, litigation funders have been doing different things to make sure the litigation funding agreements are valid, but it's not free of doubt. Let me put it this way. Let me not put it any higher than that.
This third-party funding that we're talking about, and I know that we're speaking in England or maybe even in the US, but what do you see about this third-party funding in other places, other jurisdictions if you work? And then maybe in India, do you see anything like that coming in India?
So let me make 2 points on that. So one, with third-party funding, one trend which is coming, which is I can see now, is the third-party funder wants the law firm also to have skin in the game. So the third-party funder wants the law firm to go on a DBA because then their risk profiles are aligned.
Similar,
Of course, this would mean that probably their overall pie is reduced,
Yes.
but I think they are still inclined towards law firm also going on a DBA so that everyone's risk profile is really aligned. So that's one trend. Of course, third-party funding has been going on. DBs have been going on for a while in markets like the US, the UK. I believe it's also coming into India now. Obviously, the lawyers can't partake in it, but directly with the client, there are ways around it. And I think Indian clients are now looking into
at that.
third-party funding.
Yeah, I can imagine, because with the delay that's happening and with the costs that just mushroom, at some point it just becomes unreasonable and to litigate or to continue sort of any dispute. Do you have any last parting notes? You want to give any tips to young students or something like that? Any parting notes that you want to give?
So I studied law in India at Nalsar in Hyderabad, and then I was fortunate enough to find myself in London, and now it's been 15 years.
Yeah.
I've been there, and it's been really good. Professionally, I think I've had innumerous opportunities for which I'm very grateful. So I think if I had to give some tips to people, to myself 15 years ago, I would say believe in yourself, because that's really important. You have to back yourself. Before the magic happens, you have to have that belief in yourself.
True.
And 2 is take every opportunity that comes your way. Don't be hesitant. Don't overthink it. How will I come across? Will this person want to talk to me? It doesn't matter. Just go and grab the opportunity, and you'll realize you get more and more.
Okay. And I think that's a fabulous note for us to end just this section of the podcast. Thank you.
Thank you very much for having me.